defendant's Exhibit A. I did not file it because I just, with the filing system, and it is our defense strategy, it's what you asked for. I would just ask,
It'll
you'll
be
have to
sealed.
file it, but you ask that it be sealed after you.
Yeah, it'll be sealed.
Thank you.
And you had your notes, Ms. Mitchell?
The record reflects that I'm tendering to the court my notes, all of my notes. Tendering to the court my notes on witness Aaron Robin and Maria Chavez, who are also teachers that would be located on the south end of the building.
Okay, these also were tendered to me in camera, so they'll be sealed as well after I review them.
I just wanted to also clarify for the record, Your Honor. So yesterday when I testified, after I testified, I, off the record, told opposing counsel, and I want to put this on the record, that I had not reviewed Stephanie Hale's interview with the Rangers at the time that she appeared for trial preparation. I went back to my notes. We interviewed her on December the 10th. At that time, I had not reviewed her testimony to the Rangers. It wasn't until the week of Christmas, I think all around December 26th, is when I started pulling the witness interviews with the Rangers that I reviewed her actual testimony to the Rangers. So the position that I should have had an epiphany on December the 10th when we interviewed her in anticipation of trial is misplaced, and I just wanted to make sure that that was on the record to clarify.
Yes, Your Honor, and our position on that would have been the epiphany should have occurred on the 26th when she reviewed it.
Okay. Okay, well, I'm going to review these documents that have been tendered to me in camera, but I will obviously at this point take any motions or arguments as far as remedies or proceedings in this matter. So, defense?
Yes, Your Honor. So, as the court will see from what's been tendered as far as our defensive strategy, this situation did have a significant effect on the strategy from voir dire all the way through, and through future witnesses, should they be called. We're in a position where we know under the law that we have to ask the court for a mistrial to preserve the record. However, if the court was not inclined to grant a mistrial, we do have other remedies we'd like to discuss.
Well, let me just say this. Under Heath, the greatly awaited case from the Court of Criminal Appeals about the court's discretion and power to basically, if there is a Brady violation or a Morton violation, to have the ability to exclude that testimony. And they clarified that the prosecutors, it does not have to be an intentional act. And I'll say for the record that I find, based upon what we heard yesterday, that this was not an intentional act. At best, it was a negligent act, or at worst. So I do have the remedies under Heath available, but if you're making your motion for mistrial, I will tell you I don't believe what I've heard so far without reading although I have summarized what you gave me, and I kind of already had an idea of what it was. So I guess my question is, since we talked about yesterday, the three things that were complained about was the puffing, her seeing the dirt being puffed up. Number two, identifying or saying that she saw the individual for the first time, and the location. All right, my question is on the location issue that she testified to yesterday, and frankly, I think that was kind of a very quick testimony. I'm not sure that it resonated with the jury, but my question is there going to be other witnesses that put that individual in the same location that are going to be called later by the state?
Your Honor, I would say the most probably compelling testimony are the casings in the case that would either corroborate or override what she said. I believe the location that she placed, she's from probably in the neighborhood of 100 yards away, looking toward the south end of the building, and she puts, I believe she marked in a general area south of the building, the casings are going to be closer toward the west side of the building. That is, they're going to be further west by as much as 10 yards. I haven't figured the exact date. So a witness from 100 yards away, placing a witness within a 10-yard distance, that would be the distinction. The other potential witness, Melanie Flores, testified that, would testify that the gunman, as she saw the children go into the south door, she saw the gunman at the south and west corner of the building, which I believe her testimony will put it halfway between where the casings were and where this witness says it was.
Okay. Well, I did a little research last evening, and again, I don't want to. I've reviewed your in-camera explanation of how this affects your defense strategy, and I'd already kind of gleaned what it was. So I can tell you, I'm going to deny the motion for mistrial. You have made it, and you've preserved your record. Again.
Yes, Your Honor, in addition, can I just, so I can make sure it's clear, because we all know how the courts start interpreting it later. We will go with whatever remedy the court decides if we can decide it. However, we do not believe that it's a sufficient remedy, and mistrial would be the only.
Yeah, again, I'm going to deny the motion for mistrial over your objection, obviously. And I'm going to find under Heath, although it's not a prerequisite, that it was not intentional by the district attorney's office. It was negligent, and I don't believe what was testified to in front of the jury resonated enough to significantly affect your trial strategy. But what I am going to do under Heath is I'm going to exclude her testimony.
We have just before you do that, really, I just want to know we have a response to, if you would consider that. So.
We would also have a response to that, and just so we can explain to the court that our primary concern with an exclusion is that basically what's happened, and I understand the jury, and you'll instruct the jury to disregard. I think a lot of that testimony, though, is going to be difficult for them to disregard. A lot of it is emotional testimony. One of the things that we were thinking about as a remedy would be to allow us to play her statement to the Rangers in its entirety to the jury, so that they can hear what she said in the first 4 days.
Well, I was going to give the option of, even if I exclude her testimony, you still, if you wish, could cross-examine her and do that.
Okay.
And then at the conclusion of that, my thought could be to exclude it at that time.
Yes, Your Honor. It's not, because I guess my concern would be if we excluded it now and they haven't had an opportunity for it.
I was going to give you that choice, but you jumped ahead of me.
Sorry, Judge. I'm sorry. I got a little afraid. I'm sorry.
All right, Ms. Mitchell, what do you have?
Your Honor, we just have a state's response to the defendant's motion to exclude the testimony of witnesses SH in anticipation of their motion. So I just want to file that with the court for the court's consideration. If you could file stamp this copy too.
Okay, well,
And that's my copy.
Good.
The first copy is for the judge. I'm sorry.
okay, thank you.
I just want to file a stamp copy.
Okay, so again, this is kind of a sua sponte remedy that I've devised. It's not really their motion. Did you file a written? Did you file something?
No.
Okay. Okay.
This is just anticipation of an oral motion to
Okay.
exclude, Your Honor.
Okay.
So, I don't know, Your Honor, can we confer as to possible remedies and see if we can come up with a solution? Would the court be open to that?
I mean,
Or no?
if y'all agree on a remedy, I'm happy to entertain that, but I want the record to reflect that pursuant to Heath, I do have, discretion to craft a remedy any way I see fit. But what I've already done, for the record, is we have given a continuance to the defense until tomorrow, and we're having a hearing outside the presence of the jury to entertain potential remedies and make findings of fact if necessary. But for the record, there was a motion for mistrial, and on that motion for mistrial, I'm going to find it's denied because I think the remedies available are sufficient to protect the due process rights of the defendant. And if y'all want to agree on a remedy, I'm happy to entertain that, but I have one in mind, and I'm going to give the defense some leeway on how they want to proceed with the witness in front of the jury in the event she's recalled after we talk. So take 15 minutes, y'all talk, and we'll come back into court, and I'll review the state's response to the oral motion and finish the other in-camera matters that were submitted to me. But is there a place, well, if y'all want to just go back to my office, I'll stay here, and you can go back to the office that they've provided me.
We have a room actually that they've given us over here that's.
Or you can go, actually you can go to the jury room if you want to, because nobody's there. But I'm assuming that contemplates conferring that everybody goes, the state joins you. Okay. That's fine. All right, well, y'all let me know. We'll be in recess till you come back.